My favorite aspect about litigation is preventing it. Once in the pre-litigation phase, you use your skills as a trial lawyer and as an appellate lawyer to know what is likely to happen. You have the greatest opportunity there, depending on the other side, to prevent it from going to war. You also have control at that point, because no one's going to tell you how the case is going to end up, because it's to be worked out between you and your counterpart representing the other side. That gives you the opportunity to apply skills of negotiation, diplomacy, but with a reference to what what the Harvard negotiation practice calls your BATNA, your best alternative to a negotiated settlement, sometimes called your back door. What's going to happen in litigation? Most lawyers make the mistake of following a policy of high demand, small concession. Ridiculous. I can't tell you how many times I've said to the lawyer on the other side, now wait a minute, if we go to litigation on this and I lose everything and judge agrees with you 100%, how is that worse than what you've offered me? Put a hitch in my backswing. If you think you've got a 100% case, why are you talking to me? It's a very different approach. Also, you have the opportunity, particularly in four-way meetings where the clients are present, to make your argument to the other side and reach the other side. And I've actually developed a number of my clients from having been on the other side of the table. So aside from the fact it's an opportunity to pitch business legitimately, and if the lawyer is being difficult or obstreperous, the client's a businessman or businesswoman, and if you relate to them as such, you may be able to settle the case. And the approach is to focus rather on positions. Positions are useless. Everyone knows everybody's position. You can't solve that. If you're dealing with a position, you're dealing with a distributive game. It's like there's a pie. One more piece for you is one more piece for me. So it's a zero-sum game. Businessmen don't look at things that way. Businesswomen don't look at things that way. You have to look at it as an integrative process. So what you do is you focus on what people's interests are, because interests, assuming someone's not a lunatic, are always rational. And you can identify with them, and they're reasonable. You know, what's your problem? What's the difficulty that you're facing? And if you start dealing with solving problems, you end up on both sides of the table. An example that the famous Professor Salacuse of the Fletcher School used to use is two sisters fighting over an orange. They both want to make a recipe, and they each need an entire orange. If you focus on positions, each makes a half recipe. You split it in half because they both have equal power, and they each make a half recipe. If you focus on their interests, you may find that one sister needs the zest, the outer skin of the lemon, while the other sister needs the juice of, orange, needs the juice of the orange. And that way, by focusing on interest, they both get 100% of what they need. You've expanded the pie. But businessmen and women are responsive to that because you're always trying to solve a problem. They don't deal with each other on a brute force basis. I mean, why do you think they call it a trial? That's kind of an odd word to use. You could say a request for judgment, or a request for a decision, or a hearing. It's because it evolved from, there were three kinds of trial at common law: trial by combat, trial by ordeal, and a trial by law within a court of room. That's why it's a ring. You're in a ring when you're inside the bar. It's a fight. You're too late.